If you've recently lost your job and already signed a release in favor of your employer in return for a severance payment, you may be wondering whether or not you can still pursue legal action against your employer. I'm Mike from Cashion Legal, and in this video, I'm going to break down the impact that signing a release has on your ability to pursue legal action against your former employer. More specifically, I will address the limited situations where you may still be able to pursue legal action, notwithstanding that you've already signed a release. At the end of this video, you'll have a better understanding about the impact that a release has on your legal rights and what options you might have if you've already signed a release. First and foremost, I want to get something very important out of the way. If you are thinking about pursuing legal action against your former employer, do not sign a release. Regardless of whether you think your severance package is not fair or if you think that some of your rights are not being respected, it's important that you do not sign a release before seeking legal advice. Most sophisticated employers have comprehensive releases that prohibit you from pursuing any legal action against them in the future. And if they're using these releases properly, they will be providing you with additional compensation in return for your execution of the release. By accepting this compensation and signing the release, you are creating a binding contract with your employer that prohibits you from pursuing legal action in the future. For that reason, if you are considering legal action against your former employer, you should speak to a lawyer before signing anything. If you've already signed the release and are now thinking about pursuing legal action against your former employer, your options are limited. Generally speaking, it is very difficult to challenge the terms of releases and have them set aside. Having said that, there are some limited exceptions that I will run through for you that will explain when you might be able to successfully challenge a release. The first exception that I will cover for you is the concept of duress. Duress refers to any situation where an employer applies unreasonable pressure on an employee in order to get them to sign a release. It's important to note that not just any level of pressure will reach this level of duress. It has to have an element of coercion where the employee is effectively being forced to sign the release. One common example of duress that we do see in the employment context is economic duress. For example, there is one Alberta court case where a release was set aside because the employer withheld an employee's earnings before they signed the release. This employee was in a precarious financial situation and the employer was aware of this. Given the level of pressure applied to the employee in these circumstances, the court set aside the release. The second exception that I'd like to discuss is where you are provided with no additional consideration for signing the release. Consideration is a legal concept that refers to the benefits that flow from one party to another in any contract. In order for a contract to be binding on a person, you must provide them with a benefit that they're not already entitled to. This means that in order for a release to be enforceable, an employer must provide you with some form of compensation that you're not already entitled to receive. If the release only contemplates provision of compensation that you are already entitled to, the release will not be enforceable. In fact, this is a more common mistake than you would think, because sometimes employers request releases in return for statutory termination pay. In Alberta, statutory termination pay is guaranteed by Alberta's Employment Standards Code, meaning that employers cannot request releases in return for this payment. If your employer only provided you with the minimums under the code in return for the release, your release might not be enforceable. The third situation that I'm going to discuss is where the release doesn't contemplate the specific claim that you want to make against your employer. There are a variety of different claims that can arise out of termination of employment, including claims under contract, common law, the Employment Standards Code, occupational health and safety legislation, and human rights legislation. If the release that you signed in favor of your employer mentions some types of claims but not others, you may still be able to pursue these other claims against your employer. For example, in one recent court case, it was determined that a release did not adequately contemplate a release of human rights complaints. In that circumstance, the employee was permitted to pursue a human rights complaint against their former employer, notwithstanding that they had released other employment-related claims. The bottom line is that in most circumstances, releases will hold up, although there are some limited exceptions. If you've signed a release but are now looking to pursue legal action against your former employer, you can consult with an employment lawyer to determine whether or not you still have a claim. And of course, if you have not signed a release yet, you should speak to a lawyer before you do so. If you've been presented with a severance offer from your former employer and you're looking for guidance, we can help you with this. We provide support to employees who've recently lost their job by providing them with clarity about their circumstances, strategies for next steps, and peace of mind through sound advice and strong representation. If you're looking for help, you can connect with our team by clicking the link to our website in the description of this video and booking a consultation with our office today.